will look at different perspectives in the theme of how litigating for Sri Lankan workers' rights in global fashion supply chain. So it is over to you, to the organizers, to comment. Thank you for extending this beautiful invitation to the Center for the Study of Human Rights.
Thank you, Professor. Again, welcome everyone to this webinar. And this is Abhirami Shivalogananthan, Asia Flowage Alliance Country Coordinator based in Colombo. So now, more than a year into the pandemic, the situation facing garment workers in Sri Lanka has not changed. The crisis is unlikely to be resolved without significant intervention that challenges corporate impunity and hold global fashion brands legally liable for the actions that results in human and labor rights violations in their supply chain. So when you think about, or when you take an example as a Sri Lankan garment workers employed in the supply chain of major global fashion brands found themselves without work or wages and pushed below the World Bank poverty line as global fashion brands cancelled or reduced their orders, demanded discounts, or imposed other unilateral measures through which they were able to transfer the cost and risk of the pandemic to workers in their supply chain. Global fashion brands preserved their profits and minimized any loss through these measures. Sri Lankan workers, our workers, absorbed the burn of the crisis, upsetting the business of brands in the form of economic, human, and labor rights violation. So today we are hoping to have this webinar to address the violations that took place during the COVID-19 through the Sri Lankan human rights activists, academics, legal scholars, and public can understand and discuss and provide input on pathways for a just recovery from the pandemic of Sri Lankan garment workers. So the main objective of this webinar is creating a Sri Lankan perspective to corporate accountability in supply chain, such as Sri Lanka is able to benefit from participating in supply chain through decent work, secure wages, and employment that lift workers out of poverty. So the Asia Flowage Alliance, in partnership with 23 labor organizations and trade unions across 6 countries such as Sri Lanka, Pakistan, India, Indonesia, Cambodia, and Bangladesh, has documented the wage theft that was experienced by garment workers employed in the supply factories of major global fashion brands during the COVID-19 pandemic, in order to ensure that workers are able to recover lost wages through legal claims at the national level. So now the floor is to Ms. Vishmi, the Deputy Coordinator, who will be presenting the Sri Lankan finding part of this report. Vishmi.
Thank you, Abhirami. I will share the presentation. Thank you, Abhirami. So as an introduction, I would like to familiarize all of you with the Money Heist Wage Theft Report, which was launched in July of 2021. This is important to Sri Lanka because in the Sri Lankan context, the Sri Lankan apparel industry is one of the most significant contributors to the country's economy. And the industry contributes around 7% of the GDP and 46% of the total exports. And also the apparel industry in Sri Lanka directly employs more than 350,000 people, which is about 15% of the country's total workforce. And in this context, Sri Lanka experienced 2 major waves of COVID-19 in 2020, where the first wave was between March and October of 2020, and then from October 2020. The most important fact is that Sri Lanka is the only Asian garment producing country where a nationwide outbreak of COVID-19 was directly linked to the working and living conditions of garment workers producing for global apparel brands. The COVID-19 related crisis within the garment industry began when there was restrictions in how raw materials were imported from China, And there were disruptions in the delivery schedules when the COVID-19 spread to Europe, with order cancellations and severe delays in payments for existing orders. Over time, even though Sri Lanka emerged as one of the leading producers of PPE, this was nowhere close to the income generated as an apparel production hub across the world. So when considering this wage theft report, the methodology that was followed was that Asia Flowage Alliance conducted a survey of 192 workers from 11 garment factories in Sri Lanka, which were located in 3 free trade zones, namely Katunayaka, Biyagama, and the Koggala Free Trade Zone. And when considering the factories that were selected and the average number of workers per factory, 27% of the factories had less than 1,000 workers, 55% of the factories had 1,000 to 2,000 average workers, and about 18% of the factories had more than 2,000 workforce within their factories. When considering the details of workers surveyed in this report, there were 11 factories that were surveyed. And within these 11 factories, when considering the 192 total workers, 72% were female, whereas 28% were male. And considering their work experiences, majority of them had 1 to 3 years of work experience, and next about 4 to 6 years of work experience. And majority, which is 80% of them, were migrant workers, whereas the remaining 20 were non-migrant workers. Considering the age group of the workers of the factories surveyed, majority of them were in the age group of 19 to 28, with education mostly up to the junior secondary level. And 85% of that workforce was regular or permanent workers, where the remaining 12% were manpower workers and 3% were trainee workers. So the limitation of the sampling that was conducted was that there was an underrepresentation of the manpower workers, mainly because most of the manpower workers were terminated after the first COVID-19 wave and had moved out of their resident places within the free trade zones. So therefore, it was very difficult to trace back to these workers. And this also shows that terminated workers are also underrepresented within this sample. To bridge this gap, what we had to follow was we conducted targeted interviews based on workers that reached out to unions because of certain violations that they had to face, such as illegal terminations and loss of jobs, and the lack of legally mandated compensations. When considering the wage theft estimates, according to the survey, it estimates that out of the for the 14,650 garment workers across 11 factories, they were denied $9.42 million as wages because of cancellations, non-payment, and other irresponsible practices by brands. And even though wage theft peaked in April 2020, it did not return to pre-pandemic levels throughout the year and well into 2021 as well. When considering the wage theft figures for the workers that were surveyed, the actual wage theft was $68,913 with an actual bonus theft of $24,234. And when considering the actual wage theft per factory, it was $5,945. Taking these into consideration, the wage theft estimates were a total number of workers across the surveyed factory was 14,650, and $9.42 million was estimated as wage theft across the surveyed factories. And there was an estimate of 2 million bonus theft across the surveyed factories and 1.38 million average wage theft per factory. When considering the extent of the wage theft, 94% of the workers surveyed reported that they had experienced wage theft during the pandemic period. They reported an overall wage theft of 23% in 2020, and most of this, 39%, was reported in the time period of April. It did not recover to the pre-pandemic levels in 2020, and there was an overall wage theft of around 27% during the time period of November to December as well. When talking specifically about the Sri Lankan context and its findings, the debt of workers almost doubled after the COVID-19 pandemic, where the average monthly debt increased from $6 to $17. Distress-driven employment was common for the members of the families of garment workers. And 78% of the workers were pushed below the international poverty line of the World Bank, which is measured at 3.2 US dollars with purchasing power parity between March and May 2020. Also, 96% of the workers experienced employment shocks. 85% of the workers were terminated and did not receive full severance benefits. And on an average, workers lost 21% of their work days in 2020. And also exports have reduced significantly compared to 2019, indicating the formation of a crisis. When considering the report, we have a few concluding thoughts, and that is that even though global supply chains have promised employment and ensured a pathway out of poverty for the workers, it was evident throughout the crisis that workers have always been paid way less than the living wage, even before the pandemic. And then there has been no backup for them to fall on, regardless of the poverty wage levels. And also the wage levels also over time have been stagnant, with no growth of over the lifetime of the workers, regardless of their experiences. And also there was no support by the brands during the times of crisis. Rather, there was harmful employment practices as brands canceled or reduced orders, pushing workers deeper into poverty. This shows how joint employer liability is important for Sri Lanka to be able to leverage supply chains to its benefit so that it can ensure decent employment and secure wages to workers, and that as a result, brands are held liable for violations that push workers deeper into poverty. Thank you very much. And now I would like to call upon Ms. Lakmali to take over the webinar.
Hello, everyone. I will be your moderator for the panel discussion this evening. And joining me for the panel discussion is Ms. Swastika Arulingam. She's an attorney at law and the Deputy General Secretary of Commercial Industrial Workers Union. She works closely with workers of the free trade zones of Sri Lanka and campaigns for an independently organized workforce inside mass production spaces in Sri Lanka. Professor Sarveshwaran from University of Colombo is joining us as well. He's a professor in Private and Comparative Law Department of Faculty of Law, University of Colombo. He teaches labor law, environmental law, and subjects in the area of conflict and peace studies for undergraduate programs and postgraduate programs. He has written many research articles about labor law and employment law. He's also a visiting lecturer at the Sri Lanka Law College, and he's a resource person in labor law at National Institute of Labor Studies. He's the course director for labor law in Masters in Law program in Faculty of Law, University of Colombo. He has received the Environmental Law Champion of Asia Award from the Asian Development Bank. He's also a recipient of the Asia Leadership Fellow of the International House of Japan. He was the founder director of the Legal Research Unit in Faculty of Law, University of Colombo, and he currently serves as a member of the Experts Committee appointed to draft a new constitution for Sri Lanka. We also have Ms. Achali Kumarage joining us. She's a legal researcher and an attorney at law of the Supreme Court of Sri Lanka. Achali holds LLB and LLM from the Faculty of Law, University of Colombo, and she's a second LLM from the American University Washington College of Law. She's currently a PhD candidate at the Australian National University researching on labor regulation in the supply chains of the apparel industry. We also have Ms. Shyama Salgado joining us. She's a retired ILO official. Starting off the discussion will be Swastika. Swastika will be speaking about a new litigation strategy that Asia Flowage Alliance has developed, which is called the Joint Employer Liability Strategy. This strategy is expected to recover the wages that garment workers lost during the pandemic, the COVID-19 pandemic. And the strategy will not only hold the supplier factories liable, it will also hold the international fashion brands liable. The international fashion brands who source from these supplier factories liable under the international law. So this is a redefining way of holding employers liable and defining employers as well. And this is a redefining way of, this is redefining the way supply chains are regulated and governed by Sri Lankan legal system. So first, I'll invite Swastika to discuss about the joint employer legal strategy. Over to you, Swastika.
Thank you, Lakmali. I want to start off by just going back to what Vishmi was saying about wage theft, about how the poverty, so many workers were reduced below the poverty line during the pandemic, and the fact that debt nearly doubled. So we are talking about crisis point and the crisis worsening during the pandemic. And meanwhile, when we were discussing about this joint liability strategy, and we were talking about it with not only lawyers in Sri Lanka, but also lawyers internationally, we realized that brands were making profits during the pandemic. Profits, not just covering costs, right? Profits during the pandemic, while workers were being pushed and reduced to poverty. So it was a crisis point in Sri Lanka when we finally, when we decided that something has to be done about it. And we went back to our laws. Sri Lankan labor regime is one of the oldest legal regimes of a country. It predates independence. And it has employee protection at the heart of this labor regime. So we went back to the labor laws of the country, and we realized that the definition of employer is not restricted to Sri Lankan employers, Sri Lankan suppliers. It's a very expansive definition of employer. And when you look at the way in which the supply chain is designed, when you look at the way in which brands work with suppliers and brand work with employers in Sri Lanka, the Sri Lankan labor law encompasses brands also into the definition, or the companies, the brand companies also into the definition of employer. So very simply, this is where we started. And we wrote to the Labor Department saying that there is an industrial dispute in terms of wages, in terms of workers being denied legitimate wages. And it is not only the responsibility of the local employer, which is the supplier, but it is also the responsibility of the brand. And the local employer and the brand work as one and the same. They're not two different entities. They work as one entity, despite the fact that the brand is registered in a foreign country and the local supplier acts on behalf of the brand in employing directly employing persons, but also acts in the interest of the brand, acts on behalf of the brand in also employing persons. In our complaint, we have so far submitted 2 joint liability complaints to the Labor Department. One has been accepted and a report is pending. In our complaint, we looked into several things. We looked into the way brands relate to workers in Sri Lanka, how they directly manage the production process, how they control the production process, how even the slightest of stitches, like going to the minute details of stitches, of designs, of the way an employer works in a factory, how much breaks an employee can manage to afford to get during working hours, is controlled by the way the brand instructs the local supplier to produce in Sri Lanka. We looked into all of that. We looked into great detail of how the brands work together with the local supplier in employing employees in Sri Lanka. And we strategized, or we formulated this joint liability complaint. And as I said, one of the complaints have been accepted by the Labor Department. Now, Lakmali was saying this is redefining how we look at an employer in terms of a law. In a sense, it is redefining, but also in a sense, we're also expanding the traditional understanding. I won't say the traditional scope, because I would say our law has always been expansive in terms of how it identified an employer. Our law has always been expansive. It has not just simply looked into an employment contract. In fact, when we go to a labor court, the labor court does not consider the employment contract per se as the only evidence of employment. There has been many instances where the labor court has simply disregarded conditions in the employment contract because it has found to be beyond our law. It has not beyond our law, but it has not found to be enforceable in our law, or not found to be in favor of the employee. So it's not simply the employment relationship between the employer and employee is not simply the employment contract. Our courts have looked into various tests, control tests, integration tests, and so on. There are several tests which our courts have developed and these tests have been for decades used from the labor tribunal right up to the Supreme Court. These tests have been used to define who an employee is, and have held individuals who have employed employees in various guises liable as the employer, and we have a history of that. So this is the tradition. This is the tradition, legal tradition, which has been set in Sri Lanka, which we used in the joint employer liability. And this is a new legal strategy we have developed in Sri Lanka. We have submitted these complaints in order to hold brands liable for what Vishmi has very detailedly explained regarding wage theft, regarding denial of bonuses, and which has ultimately resulted in several employees either leaving the jobs or being terminated by the employees. And I keep saying employers, and I keep saying this, that we repeatedly hear this. We repeatedly hear this in Sri Lanka, that brands cancel orders, brands are not giving us orders, and so on. But at the same time, on the other end of outside the country, we hear of brands making profits during a pandemic. So law and what happens in practice, what happens in society works together. And that is where many lawyers got together, we had a discussion and we strategized this, and we have started this litigation process in Sri Lanka. Takmali?
Thank you, Sustika, for explaining the joint employer legal strategy that Asia Flowage will be using in Sri Lanka and in other countries as well. Before we move on to the next speaker, I would like to request our participants to click on the globe icon at the bottom of your screen if you want a translation that is available. So you can click on the globe icon at the bottom of your screen. Next speaker is Ms. Shama Salgado. Next speaker is Professor Sarveshwaran from University of Colombo. Professor Sarveshwaran, can you tell us about the relevance of the joint employer liable strategy for strengthening industrial relations in Sri Lanka and maintaining industrial peace and prosperity in Sri Lanka? Why do you think is it important for foreign international fashion labels to be held responsible under the Sri Lankan law?
Okay, and good evening, everyone. So thank you very much for the opportunity. So when it comes to my presentation, I would like to divide the presentation into three parts. The first one is, who is an employer? The second one is, what are the types of labor rights violations that we generally have? The third one is, how the decisions given by, or the judgments given by our courts could be enforced in the other countries. Likewise, how the judgments given in the other countries could be enforced in Sri Lanka. So I would like to focus on these three aspects. So when it comes to the first one, who is the employer? So when it comes to the interpretation to the word employer, it is in many labor legislation. So I cite from the Industrial Disputes Act, which is the main piece of labor legislation in Sri Lanka. Here it says, section 48 says, employer means any person who employs. If I employ a person, then I am the employer. Then it says, or on whose behalf any other person employs any workman, right? On whose behalf any other person employs any workman. So when it comes to the second part of it, so here we are generally talking about three parties. The three parties are brands, suppliers, and workers. When it comes to the second part of the interpretation, here the brands will come under the interpretation to the word employer. So the brands will come under the interpretation to the word employer if we bring the brands as the principal. When it comes to the third part, there any person who on behalf of any other person employs any person. So when it comes to the third part of it, there the supplier will become the employer. So the supplier becomes the employer under the third part of it. When it comes to the first part, no problem, the direct employer. the second part, the principal becomes the employer. When it comes to the relationship between brands, suppliers, and workers, when it comes to the second part of the interpretation, the brands will become the employer. When it comes to the third part of the interpretation, they are the agent. That means the supplier becomes the employer. But when it comes to the interpretation, here it says between the two, they have used the word and. Therefore, we could argue that the brands and the suppliers both could be the employers because they have used the word and. So with that, actually, when it comes to the interpretation that I have given, it has been authoritatively cited in one judgment given by our Supreme Court, that is Carson Kumberbach and Company Limited versus Nandasena. I think there may be participants who are from legal background also. It is available in 77 NLR, page 3. There, Justice Tendakon has given the explanation at page 81. Now I go to the second part of it. So when it comes to the second part of it, because when it comes to the second part of it, generally what are the violations of labor rights? So here I don't want to go to each and every violation. Generally, as mentioned earlier, one is wage theft. So when it comes to any deduction from the wages or the earnings, here we have two labor legislation. One is the Wages Board Ordinance, other one is the Shop and Office Employees Act. So according to the Shop and Office Employees Act, section 19, only the authorized deductions could be deducted. If any other deductions are made, those are illegal. When it comes to the Wages Board Ordinance, generally the Wages Board Ordinance applies to the factory workers. Their section 2 also permits only the authorized deduction. If any other deduction is made, that is also illegal. Again, when it comes to layoff or the terminations for non-disciplinary reasons and all, we have the Termination Act. There is a procedure to be followed. If not, the terminations are illegal. So the workers will be entitled to get the employment back, or they will be entitled to compensation. These are the general violations of labor rights. Now I will go to the third part of it. The third part is, the problem here is we have generally three parties. One is the brands, other one is suppliers, other one is the workers. So brands are in the other countries, suppliers are in Sri Lanka, workers are employed in Sri Lanka. When it comes to that type of relationship, there is an international convention. The convention is Hague Convention on the Recognition and Enforcement of Foreign Judgments in Civil and Commercial Matters. That convention was adopted in 1971. Sri Lanka also has become a party to the convention, but still Sri Lanka has not made any enabling legislation to give to the principles in the particular convention. So if we give the principle of the convention into treaty agreements with the other countries and all, then we can enforce their judgments in our country. Our judgments could be enforced in other countries. So when it comes to, for an example, if we file a legal action in Sri Lanka against a brand, then the decision given by our courts could be enforced in the other country. But unfortunately, we have not gone for the enabling legislation yet. So the other one is there's another ordinance, actually, Enforcement of Foreign Judgments Ordinance 1956. Right? When it comes to the Enforcement of Foreign Judgments Ordinance 1956, there it says an ordinance to make provisions for the, right, simplify. Actually, that one also, the minister has to make the necessary order. If the minister makes the necessary order under the Enforcement of Foreign Judgments Ordinance, then the judgments given in the other countries could be enforced in Sri Lanka. Likewise, the judgments given in Sri Lanka could be enforced in other countries. So when it comes to that one, again, in Sri Lanka, if we file a legal action against the brand in another country, then finally the judgment given by our country could be enforced in the other country. But the order will have to be made by the minister, so far that has not been made. There is another ordinance, that is Reciprocal Enforcement of Judgments Ordinance. So when it comes to that one, that was passed in 1921, but that applies to very limited countries. So when it comes to that ordinance, the judgments given in the United Kingdom or other related countries could be enforced in Sri Lanka. Actually, there are two important judgments given by the Sri Lankan courts under this ordinance. One is the Associated Newspapers of Ceylon Limited versus Prince Gunasagara. The other one is a very recent judgment. That is actually Mukundan versus Plexus Cotton Limited. So that judgment has been given by the Supreme Court on the 3rd of March 2021. 3rd of March 2021. So in that judgment also, the Supreme Court has analyzed the effect of this ordinance. So then, but when it comes to that ordinance, one weakness is here. Here, this ordinance is about enforcing the judgments given in UK and some other countries, but not enforcing our judgment in the other countries. But here we are talking mainly about how we can bring the brands into our jurisdiction and give the judgments and enforce in the other countries. So I will give an example. Similar to this ordinance that I have just mentioned, there is another ordinance, another legislation passed in Malaysia. So that is Reciprocal Enforcement of Judgments Act of 1958. They say REJA. So when it comes to that one, there it says in Malaysia, foreign judgments may be enforced. So that means we will say the brand is in Malaysia, right? But in our court, we have filed the legal action against the brand. So our court has given the judgment. So in that case, according to this law in Malaysia, right, the judgment given by our court in Sri Lanka could be enforced in Malaysia without any problem. So here it says in Malaysia, based on that law, I am talking, foreign judgments may be enforced without the need to commence a fresh action. That means if our courts have given the judgment against a brand in Malaysia, then no need to file another case in Malaysia, right? But here it says without need to commence a fresh action, UK, Hong Kong, Singapore, New Zealand, Sri Lanka, India, and Brunei. When it comes to the Malaysian law, if the judgment has been given in Sri Lanka in our court against a brand in Malaysia, so that judgment could be enforced in Malaysia. Likewise, we have to explore when it comes to the country, the brands in other countries, what legal system they have. So similar to the Malaysian Act, they also may have legislation. So if they have similar legislation, then our judgments could be simply enforced in other countries. But actually now I came to know recently that the Ministry of Justice has appointed a committee to look into these matters. Very soon, I think there will be some orders and all will be made under the relevant regulations. Thereafter, we can enforce our judgments given in the judgments given in our court against the brands in other countries. Likewise, the judgments given against the brands or the suppliers in other countries in Sri Lanka. I thank you so much. And also, I think when it comes to the panel discussion, if there are any clarifications, I will. Thank you so much.
Thank you, Professor Sarveswaran. So Professor Sarveswaran spoke about the possibility under Sri Lankan law to hold international fashion brands liable for the working conditions of our workers. I would like to ask Shyama, can you tell us how international law, that is ILO standards, how can that be better implemented in Sri Lanka under this legal strategy of joint employer responsibility? Shyama?
I'm muted. Sorry. Yeah, I'm muted. Right. Okay. So now, basically, this whole discourse is about holding international fashion brands liable using laws within production countries and using their national departments of labor, as it were, or their courts, right? There are two issues here. One is clubbing the brand and employer, looking at the brand and employer relationship and conflating it and trying to make something out of it as joint liability, as we have seen, for example, I think post Rana Plaza in the Bangladesh model. We also have a model from Sweden that didn't quite work, and the workers protested and pulled out, and they felt that it was, sorry, they say start my video. Is it that you can't see me? Okay. So these are things that we have to take into consideration whilst looking at this issue. So to hold, there are a couple of questions I'd like to pose to ourselves. To hold brands equally liable, first we are redefining employers, but we agreed based on what the previous speaker said, that within the local law, the definition is so expansive that that is possible legally, right? Then we are looking at the issues. We are trying to really mine and get some justice out of the asymmetry in the relations, how they work and how they relate to workers, the brands, right? How they manage and control, in fact, right down to the breaks that the workers are given during work periods, which is a close relationship then, lends to a very close relationship between brands and employers in Sri Lanka. Now, we are looking at some of our laws that are premised on Ilo standards. And for example, inspection and inspectorates, which we have subscribed. Now we have an electronic labor inspectorate system called LISA as well. And we have a manual system, and they are run concurrently at the moment, I understand. Are you happy with the inspectorate? Are you happy with the way the Labor Department is really inspecting the employers? Will it make a difference if the employers and brands are both held liable? Or will it not make a difference? Because we are looking at the mechanism or the regulatory body and its efficiency in really bringing up the issues that we are stuck with, like non-payment of wages, unfair termination, whatever that can happen and gets exacerbated in a COVID situation. So we therefore need to respond to two important questions before we make this decision. From a regulatory approach, are we happy with the existing Department of Labor system? Because I'm going back to our original topic. How much can they cope with inspection? That also goes with the supply chain that quite often gets a little informalized. We're talking of contract labor and all that kind of thing. How successful have they been? Or are we overburdening our inspectorate by giving them this role? Next, are we satisfied with the judicial process to settle labor cases anyway? I mean, I think Dr. Sarveswaran just mentioned 2 or 3 cases. And we have a whole lot of labor issues and a whole lot of people, according to the study, who have been impacted, some 14,000 persons, workers, right? Then to make it more practical, the brands should have local officers here to represent. Is that practical? Especially in this situation, where brands pay some time to employers to ensure their interest in compliance. It was tried 10 years ago and refused and rebutted. So in a COVID context, where even that, we'll say $2 or something like that per unit, will they possibly pay for compliance? Because it has to be some kind of give and take relationship also if they're taking responsibility and liability. So even contract workers, therefore, can depend on the principle of employment relationship and the breadth of, and bring brands and suppliers to book if they really want to. But it seems it's not very practical, and access to justice is not quite there really, where it should be, right? Now let me take the other approach of social dialogue, freedom of association, collective bargaining, right? That does not necessarily get carved in black and white, but it's all about human relationships, feeling empathy, feeling bonding, feeling of, you're contributing to the national economy. There should be economic governance, therefore. And we premise this whole dialogue on ILO conventions. So for example, and one thing you have to remember is all ILO conventions have international standards, but a salutary thing about them. It's not like pie in the sky, something at a higher level. For example, they would always make provision for contextualizing. So whether it's on child labor, there are conventions, there are conditions that are, it's unconditional, right? It's universal. Then you get the contextualized things. Similarly, for example, ILO Convention 168, protection against unemployment under Article 3. The provision of this convention shall be implemented in consultation and cooperation with the organizations of employers and workers in accordance with national practice, right? So it's also national practice. They don't talk about national law per se. So local laws bind all parties, therefore, in Sri Lanka. We can invoke them if we find them suitable. But how many of us want to go into a labor tribunal? How many of us want to go into litigation? When it comes to anything, leave alone employment issues, right? So therefore, honoring ILO conventions and the spirit of ILO conventions in the workplace might bring about a better deal for all parties concerned. Of course, labor laws are important. And I have to say, in the free trade zone, when we started up initially, there was a quick battle, nevertheless. And the free trade zone workers also now fall within the scope of the labor law. Though freedom of association and collective bargain have been kind of adapted in a slightly nuanced manner to provide for some form of unionization, though there are questions about bias and effectiveness and all that, but that discourse I'll leave. I'll put it in the parking lot and leave it for another day, right? But having said that, there is a gamut of international labor standards that can be invoked locally to align with situations that could arise in terms of workers' rights. However, the gaps in implementation showed up in these times of COVID. We do not have a minimum wage, for example, as a living wage across the board for all workers. If we did have this, there would have been better opportunities to ensure that there was no wage-based discrimination or uneven reduction of wages across and within sectors. The employers, even the brands, may not have subscribed to it and been more cautious about it. So well aligned to the unemployment protection is Convention 168 of 1988. And I will just give you a flavor of some of the ILO standards in terms of conventions and recommendations that you can bring into this discourse and look at in terms of a negotiation, mediation, or almost conciliation rather than going into litigation and taking that high road at the moment where people can't even afford it. So for example, the Occupational Safety and Health Convention of 1981, number 155. Employers have the responsibility of minimizing occupational risks. This includes providing adequate protective clothing and protective equipment at no cost to the worker, right? So there is that responsibility. The PPEs, whatever is necessary in COVID also have to be provided and shall be provided according to this convention by the employer. Then there is what we call the medical care and sickness benefits recommendation. It's a recommendation, it's a guideline, it's not an imperative. It's number 134 of 1969. Workers who are absent from work due to quarantine or for undergoing medical care, such as COVID, for example, and whose salary is suspended should be granted a cash benefit. Right? It may be fairly vague at the moment, but if you are serious about negotiation, if both parties are serious about, from the workers' side, to sustain the organization so that they will have jobs in future, and from the employer's side, to give their workers who have been so loyal to them a fair deal, there is this negotiation possible within the paradigm of ILO recommendation 134. Then we come to this whole issue that impacts on women, especially post-COVID, during this whole wage clawback and all that. And Convention 156 really is the Convention on Workers with Family Responsibilities. But there is a recommendation, 165, that goes with this convention. It says workers with immediate family who need that workers' care or support should be able to really get leave within limits, of course, leave of absence to look after them without loss of pay, really, or a negotiated pay reduction. That is what is recommended. So therefore, it is very important to look to ILO standards for negotiating, because both parties are very stressed, right? There is a psychosocial ramification, not a black and white issue at the moment. So looking at it from a very robust, holistic point of view, I think it is time we also brought in these principles or these kind of the spirit of these conventions, even if they are not ratified, because Sri Lanka has anyway ratified the 8 core conventions of the ILO. And if you break down all these conventions, you can link it to one of the 8 all the time. And therefore, irrespective of whether Sri Lanka has ratified these other conventions, if we have ratified the 8 core conventions, we have an obligation to implement them. Then you get the Holidays and Pay Convention, which talks of employers should not require workers to use their annual leave to set off against this kind of situation. And employment protection and promotion against unemployment. That is another very important convention that we can rely on, because it says workers whose employment is suspended, reduced, or terminated due to COVID-19, also in this case it's COVID-19, I'm quoting COVID-19, should be entitled to unemployment benefits or assistance to compensate for loss of earnings. So we can bring this into the COVID-19 environment also and apply it. Then we do have the Protection of Wages Convention 1949. That wage shall be paid regularly. Upon the termination of an employment contract, a final settlement of wages due shall be effected as prescribed or within a reasonable period of time. And a more recent one is Recommendation 205 of 2017. It talks of employment and decent work for peace and resilience. And they're really focusing on social dialogue and tripartism will be essential, it says, in the effective implementation of measures also to address, I'm saying, issues of COVID outbreak and its impact. So I think using this recommendation is timely, it's highly relevant, and an up-to-date instrument that provides guidance to ILO constituents, representatives of the government, and employers and workers' organizations. Because if we are looking at taking the road to litigation, and we know labor litigation has not been the most successful in our country, though some, of course, have been won after a great lot of money has been spent over a great period of time, we might find that it is a better solution, and it is important not to attempt at negotiating also new arrangements, but nuance the existing arrangements in a manner that you premise it heavily on the ILO standards of fundamental principles and rights at work, and core labor standards, including drawing from some of the ILO recommendations like Recommendation 205. Therefore, you ensure your supply chain, even in times of crisis and poverty, do not engage children, for example, as might happen now, and unpaid family workers have more burdens on them. You can ensure that there is no forced labor just to meet your targets and ensure that brands do not make undue demands on labor. It is important also to strengthen the employers to challenge the brands who may make unreasonable demands on them. And to do so, the employers and workers should then build a strong relationship between themselves, premised on these respect for labor rights, premised on empathy for one another, and through robust social dialogue. So finally, the principles of non-discrimination and equality are paramount in this discussion. And remember, women get, shall we say, women's issues are exacerbated more in COVID, especially as workers juggling home life and work life. And it is important to look at the non-discriminatory Ilo conventions like 100 and 111 in this discussion. And we must ensure, therefore, that equal pay for work, equal value is followed. And the apparel sector, I think before, stood together in crisis earlier and was spouted by the tea sector as a good example. So I suggest that inter-employer bonding and dialogue with the workers would be perhaps a better way to go. But you could draw on good examples also, like the Rana post-Rana Plaza Bangladesh model, to see where you can strike a happy medium or a balance in this whole paradigm of trying to reinforce labor rights.
Thank you, Shava, for taking us through all the relevant international labor standards on this topic. And so I move on to Achali. Apparel sector has been touted as one of the main strategies of integrating into global supply chains for national economic development in Sri Lanka. Actually, can you tell us how corporate accountability for brands will help Sri Lankan national development and inclusive economic growth in that sense?
Yes, thank you, Lakmali. I'd like to first thank the Asia Flowage Alliance and the CSHR for inviting me for this panel today. And the panelists and presenters before me have covered a lot of ground and briefed us about what's happening at the ground level, national and international levels. Asia Flowage has also produced some very important contributions covering Sri Lanka's apparel industry as well as the region. During the next 10 minutes, I'm going to focus more broadly on three key aspects. Firstly, the supply chain dynamics and the governance gaps existing in the supply chains. This was discussed to some extent, but I want to expand on that in the context of economic relations and activities. Secondly, I want to focus on human rights aspects. And finally, to look at economic and developmental impacts of these reforms on joint employer liability in Sri Lanka. Of course, I won't be able to cover everything as comprehensively as I want to in the next 10 minutes, but I'm happy to discuss more during the Q&A. So coming to my first point on supply chain dynamics, if we focus on how the manufacturing hubs like Sri Lanka feature in the supply chain, it's important to understand that the supply chain no longer is a linear process. It's not bound by territorial limits, as our previous speakers pointed out. It's a lot more complex. And we see offshoring and offshoring of business operations as a result of globalization happening. It's very prevalent in the apparel industry. And why offshore supply chain operations? Of course, to claim the comparative advantage of prices. As a result, there is a lot of demands from the supplier, not just from the worker, but from the supplier at the local level for greater efficiency, for greater competence and competitiveness. Of course, this pressure ultimately translates into the worker, onto the workers as night shifts, extra hours, and hard work at the factories. And the workers bear the pressure for a minuscule wage and inadequate mechanisms to really manage the risks that they face in the workplace. So who really benefits from this system? Is it the workers? From what the other speakers have shared, it's clearly not the case. Is it the suppliers? Doesn't seem like it because they struggled especially during the pandemic too. It's the buyers or the international brands who actually benefit from the complexities and these obscurities the most. And this is not just me saying it, but international trade organizations who emphasize on a lot of benefits in globalizing business models, identify these loose or unstable relational linkages between the lead firms, which are the brands, and the suppliers. So I'd like to quote from the United Nations Conference on Trade and Development report on supply chains in 2013. They highlighted that lead firms benefit from the severe competition among numerous and almost identical suppliers and select the ones that meet their short-term requirements. So if you look at this statement, you see how these relationships are formed and shaped. So the potential negative effects of such unstable contracts particularly impact the local labor market. This is certainly not to undermine the contribution of the apparel industry to our economy, but to highlight the precarities that Sri Lankan workers as well as employers in the supply chains have to face. This was quite telling and evident during the COVID-19 pandemic, when buyers who have been earning significant profits from the industry for a long time simply withdrew from the space. They started canceling their orders, asking for discounts, and as a result, local employers could not pay the workers. And the workers at the very bottom of the supply chain suffered the most, and not even being able to buy food and medicine for their sustenance during COVID. So these complex and obscure relationships is one of the biggest governance gaps in supply chains. Swastika and many other panelists have spoken on the expansive definition of employer in the Sri Lanka's legal system. We see other jurisdictions like the United States, especially California, redefining their employer-employee relationship to address this particular gap in the supply chain. Secondly, I would like to speak a little about human rights. I know that it was touched on by the other speakers, but I'm going to highlight three key human rights that are directly related to this discourse on joint employer liability. So to ensure human rights protection, the supply chains have to be regulated at all levels, not just at the international level. Shyama also highlighted how international standards are important, but do not really have teeth at the national level. And many studies by researchers have established that self-regulation in supply chains does not work. So there are several human rights at risk, like I was mentioning before. If we take the right to a living wage, it's an important one. It's not just a wage for survival, but to fulfill the basic necessities in a worker's day-to-day lives. If you look at the Universal Declaration of Human Rights, Article 23, Sub-Article 3 and 25, Sub-Article 1, highlight the right to just and favorable remuneration for an existence worthy of human dignity. Secondly, just to speak a little, or rather elaborate a little on freedom of association, Shyama did speak on this, and I'm going to allude to the points that she raised as well. When there is a system that represses worker voice, it really represses the real problems from surfacing. And this impacts the employers to address the root causes of the existing problems. So it's important to actively protect and promote freedom of association of workers and unions within the supply chains, and they deserve a seat in all types of dialogues that affect them. And thirdly, I'd like to highlight the point of access to justice. Why is it important for us to have a national framework in place? It's not just for purposes of prosecution, but it's also to enable the workers to access the justice system. It's unimaginable for a worker to litigate against a brand in the home country of that particular brand. We have Sri Lanka is supplying to many major markets in the world, USA, UK, and Europe. So it's impossible for a worker to litigate against a brand in the current context. So this is why it's important for us to have a national framework in place to address these issues. Scholars also have noted that this area of law is moving from international soft law mechanisms and self-regulation to domestic legal regulation within countries. I quoted an example before under one of my previous points. So these reforms are timely and much needed. Finally, speaking on my third point, which is economic and developmental impacts of these reforms on joint liability. Like I said, supply chain obscurities can adversely impact the economic development of Sri Lanka, primarily because it takes away significant gains and economic security from our employers and supply chain operations. So from the perspective of the workers, the practices and the decisions of the brands impact the workers as much as the workers are integral to the business model of the brands. They a lot to do with brands, from retail, from branding, from advertising, depends on how efficiently the workers work at the ground level, how efficiently the orders are delivered. So the workers are extremely intricate to their business model and to their survival as international brands. So that as garment manufacturing hubs in the global south, we need to end impunity of fashion brands. And finally, I would also like to highlight that this is an issue on which we need Asian leadership on. We need to enroll actors and draw from the collective strength of regional apparel manufacturing hubs such as India, Bangladesh, and Pakistan, and other East Asian countries. I think I will stop there. Thank you, and Lakmali, over to you.
Thank you, actually. So we'll move on to our Q&A session. We'll move on to our Q&A session, and we've received several questions to our speakers. I'll start off with a question to Swastika. Swastika, there's a question to you asking how joint employer liability, this legal strategy that you have developed, how it will impact garment industry in Sri Lanka? Will it affect the businesses of suppliers and exporters?
In answering that question, I want to maybe build up on something which Achali was saying, because I think it's very, very important. Achali was talking about access to justice, and Achali was talking about how it is nearly impossible for workers to even think of holding brands accountable, despite the fact that we have lost $9.5 million in terms of wage theft. So it's almost impossible. What I want to highlight is the power dynamics between the work and the brands. And then actually also spoke about the rightful seat of unions in this labor relations. And why I found these 2 points very important is maybe 2 years back, holding brands, even filing this joint employee liability would not have even been thought of. But because of the COVID-19 pandemic, and because of the fact that so many unions, including the union which I belong to, the Commercial Industrial Workers Union, we got actively involved in finding means and mechanisms, finding new strategies, not even new strategies, but reviving old strategies which existed in our country to hold brands liable within the country. Now it is possible for a worker to imagine that he or she would be able to gain that lost wage. So answering your question in terms of how will it affect our business here in Sri Lanka, apparel sector business, this is how I would like to answer. An apparel sector business or the industry, there are various sectors in that industry, but at the bottom rung of that industry are workers. They go to work every day, they supply their labor, and in return, they want a wage. Workers are not charity, they're not doing charity, they are supplying their work, and in return, they have a wage. And in this whole spectrum of supply sector industry, if that wage is being denied, the rightful wage is being denied to the worker, then I don't think an industry or a sector is sustainable without paying something which is rightfully should be given to the worker, right? So an apparel sector industry, in my opinion, should only survive if it can sustain its workers, if it can supply work, if it can supply wages, if it can sustain a country by providing wages, living wages to workers in this country. So the joint employer liability is not a process where we want to destroy businesses, because that does not make any sense to us, because our workers, we are unions, right? Our workers rely on the work which is provided by factories. Our work rely on the orders which is given by brands. But what we are demanding and requesting is that brands use several human rights language. Like, for instance, brands use things like ethical labor, decent work. We stand against sexual harassment. In fact, so many brands have women empowerment slogans. And yet the very t-shirts which brands market women empowerment, it's stitched by workers who are harassed on a regular basis in local supplier factories, right? So my simple answer to that question is an industry should not survive at the absolute exploitation and indignity of the very workers who carry that industry. So if the industry is to survive, we need to start talking about the people who carry the industry in countries such as Sri Lanka. And that is what the joint employer liability is trying to do. We're not trying to undermine businesses. We want businesses, we want orders, we want Sri Lankan economy to revive, but there is a better way to do it. And we are holding brands accountable for that better way, which they market to their Western audience or market to their customer base as ethical production and so on. So we're only holding them liable to the standards which they claim in Western states. And we are saying, be held liable, be held accountable to the standards or the tools, human rights tools which you are using to promote your own products for your customer base. Lakmani.
Thank you, Sustika. Next question is to Shyama. Labor organizations have found brands unwilling to negotiate during COVID-19, leaving litigation as the only option. Even as part of the ILO call to action, brands have made no contribution and very little has changed for workers and suppliers. Has the ILO had any success in bringing brands to meaningful social dialogue with workers and the organizations in a way that addresses power differentials between them? Over to you, Shyama.
Honestly, yes, quite honestly, I am not in a position to answer that question because I do not represent the ILO here. I'm a retired member of the ILO, but I'm sure they have had many, for example, in 2019, they mooted this again to get the brands responsible for it. But I think the employers saw it differently, the employer group saw it differently. And they are still in the process of making headway in that, as far as I remember. But my memory goes back to 2019 only at the International Labour Conference in Geneva. So beyond that, I'm not sure, quite honestly, to be very frank with you, what internal arrangements have been done. But what ILO does is, I'm sure, they capture them within the paradigm of employer. And then they try to put the employer representative along with the brands to see whether they can negotiate some kind of deal. But as I said before, the employers have been a little resistant to it as of 2019. Things must have changed by now, but I am not the competent authority to answer that question.
Thanks, Shyama. Actually, would you be able to tell us about other countries where there have been efforts to hold brands liable, and whether there are successful examples and so on?
Yes, Lakmali, thank you for that question. I can actually cite some information from one jurisdiction. I haven't really looked in detail to other jurisdictions, but the most recent labor reforms are found in the Californian Labor Code and also in their penal code. It's important to look at how they redefine the term employer to include a hiring entity of an independent contractor as well. And there are other reforms to the work hours and transparency on the part of the employer so that the workers get this information. So apart from those two, I don't want to comment on that any further because we are yet to see how these provisions will really come into effect next year. And the two examples are just something that was out. And since they have really not been put to test, I don't want to really kind of comment on it in detail at the moment. But something that I want to highlight in response to that question, once again, is a point on supply chain democracy. This is something that the labor organizations have been advocating for a long time because the contracts in the supply chains are always formed between the suppliers and international brands. The workers and the other stakeholders in this process do not have access to information or rather in these contracts because these terms and conditions impact their work conditions, their jobs, their work hours. So it's important for the workers and their representatives to have access to these documents. So one other reform that the organizations are insisting on, that the organizations are really submitting for consideration is democracy of supply chains. I think that would suffice for that question. Thank you.
Thank you, actually. Professor Sarveswaran, maybe you can elaborate about, since you talked extensively about the Sri Lankan labor law, what can be done to prevent brands from abusing weaknesses in enforcement mechanisms within the Sri Lankan law and in other production countries as well?
Yeah, actually, when it comes to the Sri Lankan labor law, I would say we have enough statutes enacted by Parliament. And also, when it comes to the judicial interpretations to the important words also, I would say that our courts have given very expansive interpretations to the words employer, worker, and also and they have differentiated the independent contractor and all. So I would say that we have adequate labor statutes, but the only issue is, the enforcement of the judgments given by our courts against the brands. But when it comes to that one, but one thing, as I said, our Parliament will have to go for some law reforms, or they can make use of the existing ordinances and make the necessary orders, or they can go for bilateral or multilateral agreements with other states to enforce their judgments here and enforce our judgments there. So then if our court has given any judgment against a brand, then that judgment could be enforced in the other country, because we can't bring the brand to Sri Lanka and enforce it, but the best way is to enforce it in the country where the brand is. At the same time, as I said earlier, like Malaysia, when it comes to many countries, they have their own legislation. They have their own legal system. We have to explore better under the existing legal system of those countries. We can enforce the judgments given in Sri Lanka in those countries. So for an example, when it comes to the law in Malaysia, if our labor tribunal or our court makes a decision against a brand, that could be enforced in the other country. In that way, I think we have to work out until we get multilateral agreements, or we go for law reform to get our judgments and get enforced in the other countries. Likewise, their judgments get enforced in Sri Lanka. But anyway, now it is an emerging issue, right? Because this is another emerging issue, because now when it comes to globalization and all these, the brands, supplier and the workers that chain, right? So it cannot be broken in the middle. So then that will lead to exploitation of workers, and finally the objectives of the ILO also cannot be achieved. So therefore, I would say even the ILO also can think of another convention, right? Another convention relating to these issues, and also the Geneva Convention that I mentioned also should be ratified by all the states, and they have to undertake the obligations under the Geneva Convention as well.
Thank you, Professor Sarveshwaran. Swastika, next question is over to you. There's a question on how do brand contracts impact working conditions when working conditions are determined by the law? That is the question.
As usual, I always try to draw from other speakers also in answering questions. So I want to talk about something which Professor Sarveshwaran was saying before that. He was saying how there is ample laws passed by our parliament to protect, to even encompass an expansive definition for an employer, but also to ensure that the employee is able to even hold liable a person who would ordinarily not be considered, for a normal person would not be considered as an employer. So in terms of brand contracts and how it affects working conditions of the workers, despite the fact that the working conditions may result in what would be considered as illegal in Sri Lanka, the brand contracts, the conditions in the brand contracts, technically speaking, it can be enforced in a civil court. It's binding between the supplier and the brand and so on. So all of that is there. But the enforcement part of that is not really legal. It's actually how it is done. It is something which is practical, which is, in other words, it's political. It's how it's done. It's the power relations which is maintained between the brands and the employees. And that power relations is the only reason why brands are able to put certain conditions into an employment contract and get away with without being held liable. That power relations, as I think Achali was saying about the supply, it's the power relations, right? Which is maintained in between third world countries, like it's almost like a. So that power relations is the one which results in worker conditions. So we really look at the brand contract, there would be very strong wording on respecting freedom of association. There would be strong wording on policy against harassment. There would be strong wording on paying legal wages in Sri Lanka and so on. But when it comes to enforcement, harassment is the norm. Unions are constantly busted. Wages are not properly paid. Overtime is not properly calculated. And the brands look the other way. And it's not because they don't know what's happening, or you can somehow talk to the brands and hold them accountable. They're actually conscious. They want to have compliance. It's not that. It is, simply speaking, it's power relations. Brands are able to reach their targets. They give a certain target, and they are very well aware. I mean, they didn't start yesterday. They started this whole supply chain system started decades ago. So they're very well aware. The only way to reach these targets is to break down workers, to give indecent work to workers, to absolutely break down the dignity of workers and make them into get their subordination in order to be able to achieve certain things. So the contracts, the brand contract itself, I don't think it has anything which we could say it's illegal. But when you put certain targets, you know that breaks are going to be cancelled. You know that workers are not going to get their break times. You know that targets are not achievable by a normal, ordinary human person, and yet you put those into the contracts, and then you say we also respect freedom of association. But the issue is that workers don't have time to talk in the factory to even exercise their freedom of association. You say we are against harassment, but supervisors who also at the end of this exploitation, they have no way of achieving this target except by harassing workers, except by verbally abusing workers. This happens all the time in factories. I mean, we go to the free trade zones all the time. We hear this all the time. So in terms of brand contracts, in terms of the letter of the black letter of the contract, I don't think it has anything illegal in it. But the way it is framed, the way targets are set, the way the work is arranged, the practical result of that, the ground level result of that is exploitation, it's the denial of freedom of association, it's constant harassment, and that is how targets are met. And the brands are well aware of that. That is how I would answer that question. Akmali?
Thank you, Sastika, for giving a very clear answer on how brands are responsible for working conditions in Sri Lanka. I think that brings us to the end of our panel discussion because we're running out of time. We only have a few minutes left. It was a very insightful and very fruitful discussion, I hope, for everybody who joined us and who asked questions also. I hope your questions were answered. And joint employer liability, as a practitioner for me, joint employer liability sounds like a very delightful strategy which we can take forward and especially hold brands liable. And as everybody was saying, there is enough precedent and enough capacity in Sri Lankan law to make this a serious effort. So I hope everybody, including International Labour Organization, trade unions, practitioners, and academics, will take the strategy very seriously and try to make it successful inside Sri Lanka and outside of the country as well. Thank you, everybody, for joining us. So I will be, I'll invite Mr. I'll invite Mr. Hakim to conclude the panel discussion and the event. Thank you for joining us. Over to you, Mr. Hakim.
Yes. Good evening to you all. Thank you, Lakmali, for kind invitation. It's indeed this webinar brought together legal practitioners and scholars from across Sri Lanka. So we indeed enjoyed the exchange of ideas and information on the ways to best represent the rights and interests of Sri Lankan workers in a global fashion supply chains. So we learned today how the COVID-19 pandemic and the resultant humanitarian crisis inflicting on the garment workers, predominantly in Asia. And the presentation enlightened us more on the important question on the accountability of global fashion brands towards garment workers on their supply chains. It is a timely and worthy topic to discuss and deliberate more and more as an emerging human rights issue. I, on behalf of the Center for Study of Human Rights, as a co-organizers of this event, along with Asia Flowage Alliance and the organizing team of this event, let me extend a very hearty vote of thanks to all the speakers for gracing your important work and sharing with us your findings and opinions today on this timely and worthy topic on emerging issue. It's some of us, we learn a lot of things today because of a new topic on the floor. So therefore, we express our sincere appreciation to all the speakers for your, we are all inspired by your great thoughts and words on this topic. Let me quickly run through this program. The presentation was made by mainly on it's a AFW's wage theft report introduction and findings by the country Sri Lanka Deputy Country Coordinator Ms. Vishmi Vanachapa, and on the joint employability of employer liability legal strategy by labor lawyer of AFWA, Ms. Swastika Arulingam. Thank you so much for sharing your presentation. Your presentation laid the foundation for further deliberation by the scholars and legal practitioners at this floor. Then I have to place on record our sincere appreciation to all the speakers and the discussion, starting from Professor Sarveshwaran and Ms. Shama Salgado, and our research scholar Achali Kumarage. Thank you so much for accepting our invitation on behalf of the organizers of this event on the title Litigating for Sri Lankan Workers' Rights in Global Fashion Supply Chains. So then I have to thank our great moderator, Lakmali Hemachanda. Thank you so much. You did a very organized, very nice job, and you stick to the time, so that we appreciate for your wonderful moderation. Thank you so much for accepting our invitation, being part of this worthy exercise. And on part of the our collaboration, I have to record our appreciation for the country coordinator of Asia Flow Wage Alliance, Ms. Abhirami Sivaloganathan. So thank you so much for extending the invitation to the CSHR and to collaborate with us in organizing this event. And last but not least, our director of the CSHR, Professor Vasantha Sedivaratna, for her collaborate, for her participation in delivering the welcome note, and also her acceptance for this invitation made by this Asia Flow Wage Alliance. And I have to thank all the participants who were patiently listening to this webinar, and you have posed many very insightful questions for further clarification. So thank you so much for participating in this event. We look forward to organize similar events in the future, and we look forward to your participation. And also, I wish to express my gratitude to all the staff members of the CSHR and the Asia Flow Wage Alliance team for your cooperation and contribution. And thank you so much. God bless you all. Good night. Okay, that's the end of this webinar.